And in those treatment facilities that took women in, they weren't recognizing that they weren't just there. Once they took children in, they weren't just there to treat parents, but they were also there to therapeutically intervene with children. So we changed all that. We changed it. We forced the substance abuse facilities to become gender specific, to put seeking safety, which are manualized trauma protocol, into their facilities, to get psychiatrists on site, to deal with issues relating to education, housing, and jobs. We forced them to bring in master's level early child development specialists and to reassess how they were responding to children in their facilities. And we developed a drug court. I was able to get money to hire 5 addiction specialists, very little turnover, and we developed a continuum and a system of care for these women. And the other divisions in the court began referring there, so that most of the substance abusing parents can now come into drug court. We have dedicated DCF caseworkers, Department of Children and Family caseworkers, that work with the addiction specialists as a team. These cases are staffed weekly. And the beauty of all of this was that the 8 initial courts, the 8 initial drug courts in Dependency, were early on able to get money from CSAT and SAMHSA. And with this money, we were able to test evidence-based parenting programs, early childhood assessment protocol, and now these have become standard and systemic parts of our system, for the whole system. And we were lucky because we were able to get a NIDA grant, a National Institute of Drug and Alcohol grant, where we were able to look at the different protocols for case management. Case management as usual versus motivational case management, and to see what effect that had on reunification rates. The drug courts now, the dependency drug courts, have been widely exported across the country. I don't know how many there are, but there are hundreds. And it's largely due to the fact that the Justice Department had funding through the Office of Justice Programs, had the funding to bring teams together. Not only the judges, but judges came with their state court administrators, their state prosecutors, the lawyers for the parents, the guardians, their treatment personnel. They came as a collaborative group, and the original courts, of course it expanded after that, provided 3 weeks of training for these courts, helped them build the court, did the substantive education, we the judges with experts, and then helped with the implementation. So because of that process, there are hundreds of these therapeutic courts today around the country. And it's just accepted now. I mean, dependency drug court is accepted as the best practice, for reunifying children with parents. And what you really had here were the courts forcing treatment to get in line with the science and best practices. So they were really, it was all really court-driven. From my perspective, there's no other way to do it. I have no interest in doing this job because it has a title. If you're not going to do the job right and you're not going to make a difference, there's no reason to do the job. And I sit in the civil division as well. Many juvenile judges don't go back and forth between general jurisdiction and juvenile. The activist juvenile judges pretty much like to stay in juvenile. When I get burned out, I go to the civil division and preside over multi-million-dollar cases. And I love that as well. And I use a lot of these principles, though, to bring lawyers together, to bring parties together in that work. Obviously, it's a whole different ballgame over there, and you are really calling more balls and strikes. But you can take the skills that you get from therapeutic courts and you can really overlay them on any division of the court. My feeling is that if I'm going to do this job, I'm not just going to sit here and watch the same thing happen over and over and over. It's not why I'm here, and it's not the way that I want to live my life in any domain. And you know, the truth of the matter is that these things are not rocket science. I mean, you see the same thing over and over not working. You educate yourself about the science, and then you work with your collaborators, and judges can do that very easily to make a difference. And that's basically what we've done here. An example of not sitting by is what we're doing now with teen pregnancy. For years, our girls in care have got, large numbers have gotten pregnant. We know that girls in foster care get pregnant at twice the rates as other girls, and we also know that they are 3 or 4 times more likely to have a subsequent pregnancy before they age out of our system. So now I've just said we're not going to have this anymore. We're going to bring Planned Parenthood on site at our foster care hubs. We're going to talk to our girls about birth control. We're going to bring models in. I've been working with the National Coalition Against Teen Pregnancy, and lo and behold, my lead agency has taken this on as one of their projects. They're going to hire an executive director, all girls 11 through 24. All the kids 11 through 24 are going to have age-appropriate sex education. We're going to talk about birth control. They're going to get birth control if they need it. And we are going to start changing this cycle of teen pregnancy in our system. And really, all it takes is somebody to say, what we've been doing isn't working. We keep moaning and groaning about it. We're upset because 80% of these women come back with a subsequent baby. Well, where is our responsibility? What were we not doing? We're upset because these teenagers keep getting pregnant. Well, my daughter would be pregnant too if I didn't talk to her about birth control, and I didn't give her some sex education, and I didn't proactively try to keep her safe. So we've got to do things differently, and we've got to do them in a way that is therapeutic, that does not harm, but does more good than harm, so that our involvement with these families breaks the cycle, gives them hope, and helps them recover. So it's very incumbent on judges in these divisions, family, juvenile, dependency, to really educate themselves on early childhood development, substance abuse, mental health, trauma, and co-occurrence. The drawbacks with all of this therapeutic jurisprudence in the court is that it's extremely time-consuming. When I do drug court, I am exhausted afterwards because I'm spending so much time with the parents and putting so much energy into it. And there's a real emotional energy in the room. So it's labor-intensive, it's exhausting, and not a lot of judges want to do it. I think that all courts are confronted with building a second generation to do it, because if it's only really come into, if it's really only been acceptable in the last 10 to 12 years, you still have those original pioneers using it. But we need to build leadership that can take over, and it's not easy to do. For one thing, the people that have been doing it from the beginning are very strong personalities. They don't like to really let it go, or they want it done their way. And second of all, it's just not a lot of judges want to do it. I mean, a lot of people want to do it, but relative to the number of judges there are, not a lot of people really want to do it. It's can be uncomfortable, and it's not what they signed up for. So it's important that we really try to build leadership within our courts and identify the people that are comfortable with this kind of with this therapeutic intervention.